The doctrine of sovereign immunity essentially shields the government from liability for damages except for specific instances where the legislature has expressly waived the application of the doctrine and where there exists a mechanism by which a judgment can be funded. In Maryland, the legislature specifically waived the doctrine of sovereign immunity for the state and for units of the state in actions based on a written contract. In addition, the legislature specifically required the governor to include in his budget money that is adequate to satisfy a final judgment that is rendered against the state or any of its units. So contractors and subcontractors doing business with the state or any of its units can rest assured that they can enforce the provisions of their contracts with the state. On April 26 of 2011, the Maryland Court of Appeals clarified that school boards are also not allowed to raise the doctrine of sovereign immunity in a defense of a contractor's claim based on a written contract. In that case, BEKA Industries entered into a written contract with the Board of Education of Worcester County to construct a new Ocean City Elementary School for the board. For a variety of reasons, BEKA incurred more than $1.2 million in additional costs and looked to the school board to pay those additional costs. When the school board refused, BEKA filed suit. One of the defenses raised by the school board was the doctrine of sovereign immunity. The school board claimed that based on the doctrine, it could not be held liable for the additional costs BEKA incurred. The trial court rejected the school board's defense and after a 4-day trial, found in favor of BEKA. He entered a judgment against the school board for $1.1 million. The school board appealed that judgment and raised two main arguments in support of its appeal. The school board first argued that because it was a county school board, it was not a unit of the state, and therefore the legislature's waiver of sovereign immunity did not apply. The school board also argued that it did not have the ability to tax the residents of the county. All of its funding came from the county budget. So even if it was a unit of the state, it did not have the ability to fund the judgment, and therefore sovereign immunity shielded it. The Court of Special Appeals, Maryland's Intermediate Appellate Court, concluded that the legislature's waiver of sovereign immunity operated to waive sovereign immunity for the school board. However, the Court of Special Appeals held that the legislature's requirement that the governor include in his budget money to satisfy a final judgment did not apply to judgments against school boards. Therefore, the Court of Special Appeals ruled that BEKA had to go back to the trial court and prove that the board had the funds or the ability to raise the funds to pay the judgment. BEKA appealed this decision to the Court of Appeals. BEKA essentially argued that there was no reason why the requirement that the governor include in his budget money to satisfy a final judgment should not apply to judgments against school boards. The Court of Appeals agreed and ruled that the doctrine of sovereign immunity could not be raised by Maryland school boards as a defense to a claim arising from a written contract. It also ruled that the contractor asserting the claim does not have to prove the availability of funds to satisfy the judgment. It benefits contractors and subcontractors by eliminating the risk that a school board will not honor its obligations while hiding behind the doctrine of sovereign immunity. It benefits Maryland taxpayers because by eliminating that risk, free market competition which ensures value to the taxpayer can continue to operate efficiently. School boards can be sure that they are receiving truly competitive pricing when soliciting bids on projects. We at Harrison Law Group are proud to have had a role in this historic decision as we were selected by the American Subcontractors Association, the American Subcontractors Association of Baltimore, and the DC Metropolitan Subcontractors Association to represent them as amici curiae or friends of the court before both the Court of Special Appeals and before the Court of Appeals. Links to the briefs we filed on their behalf and to the court opinions can be found on our website. If you'd like more information, please contact me at 410-832-0000. Thanks for watching.